Okay, hello, and welcome to this Advocacy in Action webinar, which is brought to you today by the Sargent Shriver National Center on Poverty Law. My name is Amanda Moore, and I'm a Senior Attorney Editor at the Shriver Center. I will be moderating today's webinar, which will focus on alternatives to guardianship and preserving the autonomy of individuals with intellectual and mental health disabilities. So it looks like we have, it's growing all the time, the number of attendees who are already logged in, creeping up upwards of over 100. Now during the course of our webinar, we'll be asking you to submit your questions for our speakers in the question box to the right side of your screen. The things you type in the box will be visible only to the webinar organizers, not to everyone on the call. So just to get some practice with that and so we can see who's out there, why doesn't everyone go ahead and type your name and where you are in the question box and submit it? You can just submit your first name and your city and state just to give us a sense of where we are. Oh, okay, they're coming in very quickly. Let's see. I see Amy in Chicago and Norma in Austin, Denise in Massachusetts. We've got people coming in from everywhere. And I'm in Murfreesboro, Tennessee. So there's Joy in New York. So anyway, welcome everyone. Before we get into the substance of our webinar, let me take a few minutes for some housekeeping matters. All attendees are in listen-only mode, so we shouldn't hear anything except our presenters. If you have a question during today's webinar, please feel free to post it in that question box you just used on the right-hand side of your screen at any time. We are recording today's webinar, and we will post the webinar afterward on the Shriver Center's website. We will send an email to everyone who registered for today's webinar within the next couple of days, and that email will include a link where you can access the recording of the webinar. We're hosting this webinar today in anticipation of our May-June issue of Clearinghouse Review, Journal of Poverty Law and Policy. This May-June issue will focus on disability law, and it even includes an article by one of our presenters today, David Hutt of the National Disability Rights Network. It will also include an article on alternatives to guardianship by Judge Kristen Booth Glenn, and I believe we'll be hearing about some of Judge Glenn's work today during our speakers. This issue of Clearinghouse Review will be published in early June, and if you do not already subscribe to Clearinghouse Review, but you would like to be notified when this issue comes out, you can sign up for our monthly e-newsletter, which is called Clearinghouse Review News. Now, the June issue of this newsletter will include links to all of the articles in the disability issue of Clearinghouse Review. You can sign up for Clearinghouse Review News at povertylaw.org/advocacy/signup, and in a minute I'll post that link in the question box on the right side of your screen so you can all see it and it'll be easy for you to access. And on that site you'll just need to check the box News about Clearinghouse Review and other publications. Now, for the substance of our webinar. Here to talk with us today about alternatives to guardianship are three leaders in the field. We have Bob Fleischner, an attorney and the Assistant Director of the Center for Public Representation, which is based in Northampton, Massachusetts. We have David Hutt, a Senior Staff Attorney with the National Disability Rights Network. David is based in Washington, D.C., but he's joining us today from Minnesota. And we have Rebecca Diller, an Assistant Clinical Professor and the Director of the Guardianship Clinic at the Benjamin N. Cardozo School of Law in New York. I want to welcome our presenters and thank them for sharing their expertise with us today. Bob and David are going to present first. They'll be tag teaming their presentation on supported decision making. Rebecca will follow, and she will talk about strategies for pursuing even more alternatives to guardianship. But we'll pause about halfway through Bob and David's presentation to give all of you a chance to have your questions answered. We'll spend about 5 minutes on a couple of questions before they resume their presentation. We'll then spend another 5 minutes or so on questions for them at the end of their presentation. And I want to encourage all of you out there to submit your questions for them while they are presenting. So that way, we will have those questions ready for them as soon as they conclude. And then we'll take questions specific directly for Rebecca for about 5 minutes after her presentation, and we'll spend the rest of our remaining time with questions for the speakers that they can discuss together. The webinar will end at 15 past the hour. Now, before I turn this over to Bob and David, all of our speakers wanted to get a sense of the audience. So we have a couple of poll questions for you. Those should be popping up on your screen in just a minute. Aha. All right. Our first question is, have you been involved in any capacity in a guardianship procedure, either establishing, limiting, expanding, or removing a guardianship? And that one you can answer with a simple yes or no vote. And we'll see the results where are results up? Aha, yes. Okay, most of you have. We have 66% of you have been involved with the guardianship procedure. So we have a second poll question for that 66% of you who have. It's a bit more specific, and we'll wait for that question to pop up. Aha. So if yes, if you have been involved in this, in what capacity were you involved? Your choices are that you represented the petitioner seeking a guardianship, that you represented the person who was the subject of the guardianship, you are the guardian or the proposed guardian, and we have a couple other choices, that you're a guardian ad litem or a judge. Okay, and it looks like over half of you represented the person who was the subject of the guardianship. About a third of you represented the petitioner seeking the guardianship, and we have about 13% of you were guardians or the proposed guardians. So that should give our speakers a bit of a sense of who's out there and what your experience has been with the guardianship system. Well, I want to thank all of you, whatever your experience has been, for attending today. And I will now turn this over to Bob and David. And I'll remind all of you out there that you can submit questions at any time through that question box on the right side of your screen. Okay, Bob and David.
Hi, everybody. This is Bob Fleischner. I'm at the Center for Public Representation. We're a public interest law firm in Northampton, Massachusetts. I'm going to talk make some introductory comments about guardianship, and then David will talk about supported decision making specifically, and at the end I'll talk to you some about a supported decision making project that we're undertaking in the western part of Massachusetts. So we're assuming that everybody has some basic understanding of what guardianship is. That seems particularly true from the poll that we just took. I think everybody knows that many individuals with disabilities need some kind of assistance with one or more aspects of their lives, and that a typical response for those people who may need assistance is guardianship. And that guardianship is a state action that's taken on under what's usually known as the state's parents patriae authority, and is intended to protect a person and provide for a person who's unable to provide for or protect themselves. The Center for State Courts estimates that there are likely, they were only able to make a good guess, to be between 1 and 3 million pending guardianship cases in the United States in 2011. So there are lots of aspects of guardianship that are helpful and which can be helpful to a person. So what's so good about guardianship? One of the things is that guardianship provides legal clarity about who it is that needs a guardian. That is, that it sets standards for guardianship. So there's some way to tell if a person is in need of a guardianship or not. It offers a form of protection and provides safeguards against abuse. These safeguards could be abuse and protection from third parties, or in some cases might be protection even from the guardian, him or herself, a protection that's provided by court oversight. It provides a clear format and a clear legal standard, or at least a reasonably clear legal standard, for the guardian to make decisions. Usually the decision-making standard for guardians is described as either a best interest standard, making a decision that's what's in the best for what's in the person's best interest as determined by the guardian, or a substitute decision making basis, which is where the guardian tries to decide what it is that the person, him or herself would do if they could decide. One of the clearest advantages to guardianship is that it makes clear who is the decider. Everyone knows, or should know, that if a person has a guardian, that the guardian is in charge, and the guardian has the authority to make either a lot of decisions or some decisions, depending on the nature of the guardianship. It ensures that there's someone with authority to act in an emergency, and it provides third parties, particularly probably healthcare professionals, healthcare providers, and banks, certainty about the validity of decisions and actions. But there are some very important aspects of guardianship that are problematic. The most fundamental is what Robert Dinerstein, Professor Dinerstein, calls civil death, and that is that the person becomes totally, potentially totally under the control of another person. It's a loss of legal personhood. In every guardianship, whether it's limited or whether it's plenary or full, there are serious and even fundamental liberty rights and interests that are at stake. There's a loss of independence, possibly a loss of self-expression, sometimes a loss of the right to be integrated into the community, into society. This is particularly has been true with individuals who are either want to leave institutions or for whom the government is about to provide an alternate, less restrictive alternative in the community, but whose guardians, for one reason or another, oppose them. There's a loss of dignity that I think is inherent in any kind of guardianship. And there's the loss of the dignity of risk, by which I mean the ability to take chances in life and to take risks, because it's by taking risks and chances that we all learn and grow. There's a learned helplessness that's part of guardianship. When someone else is making all your decisions for you, there's less incentive to make them for yourselves. And importantly, for those of us who take a legal rights view of this, there's loss of civil rights. Depending on the state and depending on the laws in that state, that could include the right to marry, to vote, to associate, to sexual expression, to where to live, to accept or refuse medical treatment, and so on. That, of course, is all state dependent and dependent on the type of guardianship. And there's the possibility of exploitation by the guardian. It's really been guardian exploitation that has led to guardianship reform in the United States. Early articles several decades ago by the Associated Press of guardians stealing money from their wards led to the first round of guardianship reforms. Also, reformers, advocates, people with disabilities, their families, in many states led to and advocated for statutory changes to enhance liberty, often by adopting parts of the Uniform Probate Code or the Uniform Guardianship and Protective Proceedings Act, both of which are model codes that many of you are probably familiar with, that include some very positive reforms and provisions for guardianship. The kinds of reforms that have been most typical are placing limits on guardians' authorities, encouraging the use of limited guardianships where guardians can decide some things but other decisions are left to the person under guardianship. Ensuring that guardianship is a last resort by requiring alternatives be used in the first instance, powers of attorney, healthcare directives, all of which you'll hear about later in this presentation. And finally, the reforms have included providing enhanced due process protections, providing lawyers in some or all cases, notice, simple things like requiring that the person has a right to be present at all the hearings and has a right to participate in those hearings. One of the major reforms in the Uniform Probate Code and the Uniform Guardianship and Protective Proceedings Act was the codification in the states that have adopted it of a definition of capacity or incapacity, competence or incompetence, dealing with mental capacity. And we're going to talk about something called legal capacity a little later. David's going to talk about that. But thinking of mental capacity. And under the more antiquated laws, the basis for a guardianship was usually categorical. So if a person had an intellectual disability, what used to be called mental retardation, or was had a mental illness, or was old, or was a spendthrift, spending all their money, that in itself, sometimes with an inability to take care of themselves, was often the standard for getting a guardian. The UPC and the UGPPA changed that and adopted a functional impairment test, which is set out on the slide. And that's basically an inability to receive and evaluate information or to make or communicate decisions to such an extent that the individual lacks the ability to meet essential requirements for their own physical health, their safety, or their self-care, even with appropriate technological assistance. And the UPC and the UGPPA both recognize that competency or capacity is on a continuum, and that a person may be competent for one purpose, although not necessarily for another, and they encourage limited guardianships. So I'm now going to turn it over to David, who's going to talk about some other things, and I'll be back again soon.
Okay. Thanks, Bob. We're just going to show my screen here. Okay. Hopefully the slide is coming up there. Okay, as Amanda said, I'm David Hutt with the National Disability Rights Network, and we are the membership organization as well as the training and technical assistance provider for the protection and advocacy agencies. And I know we have a number of protection and advocacy agencies on the phone. Let's get my slide back up here. But for those that are not familiar with the protection and advocacy system, just let me briefly tell you a bit about the system. The P&A system was created and is funded by the federal government, but it's operated primarily through nonprofit organizations in each of the states and territories, with several states have independent state agencies that are the protection advocacy agency in their state. Now, it's called different names in different states. You may hear for example, Disability Rights New York or Disability Rights California. That's the protection advocacy agency in those states. Other states, it's called the Disability Law Center, such as the Disability Law Center in Alaska or the Maryland Disability Law Center, or you may hear the Advocacy Center, which is the protection advocacy agency in Louisiana, or Equip for Equality, which is the P&A system in Illinois. Now, collectively, these federally funded P&A agencies are the largest provider of legal advocacy services to individuals with disabilities in the U.S. The P&A system obviously is getting involved in guardianship issues with individuals with disabilities, as well as other decision-making cases, whether it be power of attorney or other alternative forms of decision-making for individuals with disabilities. Now, in terms of the guardianships, P&As are involved in eliminating guardianships, obtaining the appointment of a new guardian that's chosen by the individual, so the individual's unhappy with a guardian, they want to get someone more of their choice. More importantly for our discussion here, reducing the authority of the guardian. So for example, if an individual has a plenary guardian, the P&A will work to reduce that perhaps to making the guardian only about making medical decisions for the individual. So giving the individual with a disability more autonomy in other areas of their life. The P&As also report a lot of abuse and neglect with guardians. I'll just give you a few examples before I talk a bit about the supported decision-making model. Just some examples, and these are from the medical treatment context. For example, a P&A was approached by a friend of the ward, who the ward had pneumonia. The guardian put the individual into hospice care, was not seeking medical treatment for the individual. The P&A advised the friend to report this to the county adult protective agency, and eventually the individual got out of hospice care and was able to recover. Another example, an individual had a family member, and this family member had a power of attorney over healthcare decisions. The family member brought the individual with a disability to a medical center, but the power of attorney was refusing to consent to medical care. She only wanted comfort measures for the ward. The P&A was contacted. Fortunately, the medical staff did not follow the directive of the power of attorney, and the P&A worked with the individual to get rid of that power of attorney and ultimately to find another living situation. Unfortunately, his medical condition improved. And then finally, one other case in the medical field, individual with an intellectual disability and had a family member as a guardian, and this individual needed significant supervision. The guardian, however, decided they did not want the individual to have counseling, even though the treatment team was requesting it or thought it was certainly in this individual's best interest. The ward himself was greatly upset when the guardian got rid of the counseling because he thought he was making good progress. So the P&A fortunately was able to intervene and get a new guardian that was able to get the person back into counseling. Other issues around where the person lives, the guardian putting people in assisted living facilities when the ward could clearly live in the community, or some issues that the P&As get involved in. So we obviously see problems in the P&A network with guardianships and sort of these overriding deciders of individuals with disabilities. And before I get into a little bit more of the nuts and bolts of supported decision making, two cases that I think sort of give an idea about where the trend is going in some cases. These are P&A cases. In one case, the Child Welfare Agency was seeking to hold on to custody of a 14-year-old with PTSD. The Protection Advocacy Agency was able to intervene to basically get the girl back with her grandparents, and instead of some sort of oversight by the state, the grandparents were given intensive home support, so that individual was able to stay in the community without having to have a guardian or a state custodian in that case. In another case, the P&A was approached with a case where a hospital and a physician was refusing to perform medical procedures on an individual that the hospital believed could not provide informed consent. The hospital wanted a family member to do so. The individual did not have a family member, but in this case, the individual did have a friend who was also a service provider that this individual trusted, and the P&A, under a change in state law, was able to execute a healthcare proxy where the friend was able to be the healthcare proxy. The individual was then given the medical treatment based on this friend. And it's this key, having the support, which is what I'm going to talk about next, is this key about supported decision-making, is essentially keeping or allowing the individual with a disability to keep their autonomy, keep their ability to make the decisions, but to have supports from friends, from family members, from appropriate people to be able to retain that ability to make those decisions. Now, this whole discussion about supported decision-making is coming from the Convention on the Rights of Persons with Disabilities. This is where a lot of the discussion, both internationally and domestically, is happening on these types of this supported decision-making model. On the next slide, just a quick overview before I get into a little bit about the CRPD. Currently, the last World Health Organization reports that there's about 15% of the world population, or about 1 billion people, have a disability. And if you note on the third bullet on the slide, the World Health Organization also notes that the population is aging, and that's increasing the number of people who have disabilities. But I think this is also important in this discussion about supported decision-making, as individuals, whether or not they have a disability or not, as they aging, as they cognitive functions decline, as this is a discussion about decision-making capacity in the aging population as well as the folks with disabilities. I think this model of supported decision-making is going to be important in how to allow that individual to retain as much autonomy as possible. Now, the CRPD, for folks that don't have any familiarity with the convention, it was basically drafted at the United Nations. The General Assembly in 2006 adopted the text or voted the text out, which allowed then individual countries to go and ratify the treaty. In 2008, a very, very quick turnaround. This is the first major international human rights treaty of the 21st century, and one of the quickest to, quote, enter into legal force, which basically meant enough nations had ratified it that those nations which had ratified the treaty or legally adopted it were now legally bound in international law to follow the provisions of the treaty. There's actually, the slide says 142 nations, but even in the last month since I did this slide, we've had 2 other countries that have joined it. So there are now actually 244 nations who have ratified the CRPD and are now legally bound to it. I think Switzerland was the last country to ratify it several weeks ago. The United States currently is a signatory to the CRPD, which essentially means that we need to essentially not frustrate the purpose of the treaty. So the U.S. is not bound to individual articles. It's not bound to other nations under international law to follow the treaty, but the U.S. has to basically uphold the general principles of the treaty, which the U.S. government holds as a non-discriminatory treaty. On the next slide, just quickly for folks' references, those like a visual reference is just a map showing in the blues and the reds who have ratified the treaty, and then the dark gray and the yellow indicate those nations that have not yet ratified the Convention on the Rights of Persons with Disabilities. Now, the discussion around supported decision-making is under Article 12 of the CRPD, which is titled Equal Recognition Before the Law. And on the slide are three of the paragraphs. Let me focus on actually paragraph 2 and 3 first. Paragraph 2 says that states which have ratified the treaty shall recognize that persons with disabilities enjoy legal capacity on an equal basis with others. Essentially, the way that the discussion has evolved around paragraph 2 is that legal capacity does not equal mental capacity. Legal capacity is that the decision of an individual will be recognized by hospitals, by banks, by members of the community. And it's not equal to the individual's mental capacity, which is a bit of a change there. In paragraph 3 of Article 12 states that nations who are parties to the treaty need to provide support to individuals with disabilities so they may exercise their legal capacity. Other articles of the treaty talk about providing accommodations to individuals, allowing access to justice. So that read with paragraph 3 means that states really have to make an effort to allow for those supports or to recognize those supports for individuals with disabilities in making decisions. A lot of the discussion has been around that this support does not mean providing guardianships. It means more than that. It means allowing the individual to be able to retain that ability to make a decision. Moving to the next slide, which talks about safeguards. A couple things I want to point out, and this is actually paragraph 4 of the CRPD, is first of all, the article talks about safeguards to prevent abuse. So the treaty language recognizes that individuals with disabilities, that they, there needs to be some safeguards by the country to prevent abuse and neglect of the individual, them from being taken advantage of by others. So the treaty drafters recognize that. However, the part in red, which I'm going to read, is really, I think, one of the most important aspects of this article. It says that these safeguards shall ensure that measures relating to the exercise of legal capacity respect the rights, will, and preferences of the person, are free of conflict of interest and undue influence, are proportional and tailored to the person's circumstances, apply for the shortest time possible, and are subject to regular review by a competent, independent, and impartial authority or judicial body. So this is important because, one, a plenary guardianship that's put in place for life with no review, no oversight for the court is certainly would not be up to the standard required under Article 12. And even many of the discussions that even going to guardianship first without considering other alternatives would certainly not be what is intended by Article 12 of the CRPD. And essentially this idea of supported decision-making is really, as I said, is the crux is to keep the decision-making with the individual with a disability and just providing those supports. So on the next slide are some of the principles of supported decision-making. First of all, that people are inherently are not inherently incompetent, so they're inherently competent to retain legal decision-making authority. Secondly, that everyone has a will and a preference. And under the this provision, just quickly, I point out that Germany actually has put this in their guardianship provisions. I'm certainly not an expert on German law, but essentially in Germany they have eliminated plenary guardianships, and the court needs to look at first of all, it prohibits the court from appointing a guardian against the free will of the individual, but the court must decide and consider whether the disability prevents the individual from being capable of free will. So they actually take the language of the treaty, and the courts need to look into that. Under the next bullet, one of the principles of supported decision-making is that the individual may need a communicator. So this individual with a disability may have difficulties communicating their wishes, but a close family member, a close friend who knows this person well may understand how the individual communicates. So clues and other methods the individual may use is a way that supported decision-making can be implemented. The other aspect, and I just want to briefly, before turning it back to Bob, or before going to questions, and we'll turn it back to Bob, the other mechanisms of supported decision-making is the idea to provide a supporter, someone who can help the individual interpret or explain in simple language what a decision, the implications of a decision. And there's been movement of, especially in Canada, some of the provinces in Canada, to put this into law or to put legislation or to have that supported decision-making agreements which require banks, hospitals, other individuals to allow this supporter, this person that's going to help the individual make the decision, to be involved in discussions, to have access to health care, healthcare information, those kind of things, to allow that individual to help the person with a disability to make those decisions. And then finally, before we turn it over to questions, I think this sort of encapsulates, and Bob's going to go a little bit more into detail about a project in Massachusetts, but I think this encapsulates what, on the next slide, what supported decision-making the goal is. It's still an evolving, developing process, but as Professor Ditterstein says, it's a series of relationships, practices, arrangements, and agreements of more or less formality and intensity designed to assist an individual with a disability to make and communicate to others about the individual's life. So I think we're going to stop here for a few questions.
Sure. Thank you very much, Bob and David. We have had some questions come in. First, just quickly, we've had a few questions come in about whether these slides will be available to presenters, to attendees, and the answer is yes. We will post these on the Shriver Center site within the next couple of days, and everyone who registered for the webinar will get an email that will link to this webinar. It will be recorded, so you will have access to them. Second, one other quick point, we had a listener in California remind us that in California, these guardianships for adults are actually referred to as conservatorships. So just a point to note. Now for a question. We had a question from Jan, wondering if there are any state statutes at this point that address supported decision-making as an alternative to guardianship.
This is Bob, and the answer to that is not that I'm aware of. There are models of supported decision-making statutes in several Canadian provinces, particularly in British Columbia, where it is a legal process. And as David alluded to, there's a lot of activity internationally in a wide, very, very different countries, Scandinavian countries, Ireland, some of the countries in Eastern Europe, to either abolish or to substantially limit guardianship. Sweden has replaced many guardians with something they call a God-man, with a small g, and so to look for statutes, it's probably important to look internationally rather than the United States. The closest thing that we have here, I think, are statutes that call for limited guardianships, that really support in communication by the guardian with the individual under guardianship, and require the guardian in many circumstances to make decisions that are based either on the express preferences or the deemed preferences of the individual under guardianship. And just to go back to the point that was well made before, same thing's true in Connecticut as California. Guardians are called conservators, and in Louisiana I think they're called curators. So we're using guardianship in the more common term, but it's good to keep in mind that a conservator in Connecticut or California is not the same thing as a conservator in Massachusetts or other states.
Okay, great. We have one other question before I turn it back over to you. We have a few questions. Some of these coming in I think will be addressed in the second part of your presentation, so I'm going to hold off on those. But we have one that's a point of clarification that I think we could address briefly. What are the differences between a guardianship, a power of attorney, and a medical proxy? Because they seem very similar in some respects.
This is Bob again. The biggest difference between the three is that only a guardian is appointed by a court. Powers of attorney and healthcare advance directives are things that are written and executed by the individual himself or herself, appointing someone to make decisions for them, for him or her, usually when the person is no longer capable of making the decision, although it doesn't have to be that. So the biggest difference is court appointment and not court appointment.
Great, thank you. Okay, we'll hold the other questions we've received until after you finish, Bob, and I think, Bob, you're going to take it up from here. Is that right?
I am.
Okay, thank you.
And I just have to go forward to the correct screen here. So here we go. David's already alluded to this, and I won't spend much more time on this, but it's an important concept of under the Convention for the Legal Rights of People with Disabilities, is this concept of legal capacity, and this is the reason why we're re-emphasizing this, and that state parties who are participating have an obligation to provide access and support so that people can exercise their legal capacity. It's also worth noting, just to return for a second to some of the things I was talking about before, the road to reform has not always been smooth. There has been some reaction to reforms, and particularly in some states for people with intellectual disabilities, there have been statutes which have been designed to make it easier to get guardianships, and most of these are designed for families who are having their children age out of service systems at age 18 or become adults, and sometimes those families have pushed for easier procedural and substantive standards. But if concepts of legal capacity and mental capacity are to become integral or part of the law in the United States, and and talk in a few minutes about ways that they're beginning to. They are not the same thing, as David said. They look at the wills and preferences of the individual and find that to be the core of decision-making abilities, and focus on preferences and on accommodations and supports to the individual to guide the decision-making process. There is no one pure, simple, across-the-board way for supported decision-making to be implemented. As David said, this is going on around the world. There's no single model. Familiar models that may be familiar to many of you that are used in social services and in fact throughout human existence can be made part of the supported decision-making process. Circles of friends, person-centered planning, both of which are paradigms and systems that are used in working with people with disabilities, can be integrated into a supported decision-making plan. The plan and the process can be formal or informal. It can be court-sanctioned or not. It can have the support and the authority of the state, as it does in British Columbia. So in the SDM system in British Columbia, there is a fairly routine contract that everyone who's involved in the process signs, and that contract is given legal weight and authority in British Columbia, so it is supposed to be followed by people who interact with a person who normally or formally might have been under guardianship. No matter what the system is that's implemented, it's important to build in safeguards, because supported decision-making processes and plans seldom have court oversight. In some places where SDM has been implemented, it's been done through human services providers, and there's been someone who acts as a monitor and an assistant to what's going on. In other places, that's found to be too intrusive and it isn't used. There have, as I said, been several cases in the United States where courts have begun to recognize supported decision-making as a practical alternative to guardianship. Probably the most well-known of these cases is what's known as the Jenny Hatch case, which is Ross versus Hatch in the Virginia court, the city of Newport News, Circuit Court for Newport News in Virginia, a 2011 case that's gotten deservedly received a great deal of public attention in the popular press and in legal writings. It was a case brought by the Quality Trust, and it is a case in which a young woman with intellectual disability was placed, instead of under a full guardianship, under a limited guardianship for 1 year, the ultimate goal of transitioning her to a supportive decision-making model where she would be free of guardianship. Perhaps the most useful case in terms of being a published case and being one that has a very useful and very helpful kind of legal reasoning is a case called Guardianship of Damaris L. That was a case before Judge Kristen Glenn in the Surrogacy Court of New York, and Judge Glenn, as you've heard, is doing an article for the forthcoming number of Clearinghouse Review. And in that case, Judge Glenn took a look at the capacity of Damaris L. She looked at and considered New York state law, and in a lengthy part of the decision, she drew on the Convention for the Rights of Persons with Disabilities, and used that to guide and gave it persuasive weight in interpreting our laws and constitutional protections, New York laws and constitutional protections, and finding that Damaris L. would not need a guardian because she had a group of supports and friends and accommodations which assisted her to make the decisions in her life in which she had some difficulty making. So the biggest advantage to the Damaris L. case is that it's a published opinion, and it is filled with very useful reasonings and citations. Disability Rights Texas, which is the protection and advocacy agency in Texas, has also used supported decision-making theories in a Texas guardianship case that attorney Robin Thorner of Disability Rights Texas wrote about in a recent edition of Clearinghouse Review. So there actually are, although there may not be any clear statutory support that calls it supported decision-making, there clearly are some judges and some courts that are willing to interpret state law to allow for supported decision-making processes and plans. So we have tried to take a view of this in the western part of Massachusetts, and we have started a pilot project here to try to bring a supported decision-making plan and project into what are the 4 western counties of our state. We're doing this jointly with Nonotuck Resource Associates. Nonotuck is a shared living provider. That means that they provide services primarily to people with intellectual disabilities who live in the homes and become family members to people. They don't live in group homes. They're not living in institutions, but they're living with families. We're a public interest law firm, as I said earlier. About 2 or 4 months ago, we began this process after some pretty long and intensive research onto what this would be and some meetings with Nonotuck. We held a planning meeting. We invited some of the experts in the country, including Judge Glenn and Michael Bach, who's one of the leading thinkers about this from Canada, and people from the United States and Mexico and other places who had experience with this, including representatives of NDRN and the ARCs, which are family associations, and others. We also were very fortunate to have most of the probate court judges from the western part of the state at the planning meeting, and we were very pleasantly surprised at how supportive the judges were of this process and this idea. And in fact, we've learned from one of the judges that since she came to the process, she has not granted a single plenary guardianship, but has limited guardianships in every case that's come before her since the planning meeting, and has encouraged people to be looking at supported decision-making models as an alternative to guardianship. So we've had some minor impact already. But we've taken that planning meeting and developed a pilot project in which we plan to assist approximately 10 individuals with intellectual disabilities and their families in the western part of the state to design and implement supported decision-making plans as an alternative to guardianship. My office, CPR, will, among other things, provide legal representation to the individuals where that's necessary. We've established, and I think this is very important, a very good family, client, professional advisory council. We have former judges, and we have bankers, and we have doctors, and we have clients, people with intellectual disabilities and their family members to advise us as we go forward on this. And we've hired an outside evaluator. Although our project's going to be small and the research will not be conclusive because of the small sample, but we want an outside evaluator to rigorously study what we're doing and to report back to us on whether it works and what doesn't. We have no, at least not yet, we have no set method that we plan to use in this process. We are going to try to adopt the supported decision-making plan and method to the individual and see what works best for them. We're also trying to serve as wide a variety of individuals as we can to be able to test this not just with people who are at the least risk of guardianship, but people who are actually under guardianship, who have different levels and degrees of disabilities, and who have varying levels of personal and service support available to them. We think that this is an opportune time for this to implement strategies and bring meaningful and even revolutionary reform to concepts of substituted decision making. It's time to think, it's a good time to think about guardianship in a new way to create new opportunities for people with disabilities, enhancing their independence but providing them with the necessary and desired levels of protection. So I think that's the end of mine. David's going to talk about some resources, and that'll be it for us.
Okay, real quickly here, there are several resources that are talking about supported decision-making. The National Guardianship Network and the National Guardianship Association are starting, will have been having discussions around alternatives to guardians and SDM for a while. The ABA Commission on Law and Aging has some very good materials on guardianship and a wide range of issues. The World Congress on Adult Guardianship, which is going to be actually held at the end of this month in Crystal City, Virginia, is actually, I think, at least half, maybe a third to a half of the sessions are going to be on supported decision-making. In fact, the three of us as presenters were just talking about it before, how much supported decision-making is a part of that conference. So there is a lot of interest, a lot of talk about this, both in the U.S. and globally. And then finally, as Bob mentioned, the Hatch case, which has gotten a lot of public attention, and the Quality Trust has actually an entire project around Jenny Hatch. For those that are interested, they actually are running a number of webcasts. They've actually done 2 so far. I think they have a 3rd scheduled, and the recordings are available on their website to learn more not only about the Jenny Hatch case, but also some other more detailed issues about supported decision-making. And I think just the final slide is just the contact information for both myself and Bob.
Okay, great. Thank you both. We have had several really good questions come in while you were speaking, but I want to make sure that Rebecca gets her full time because she has some great stuff to share with us too. So I'm just going to ask one question and ask that you can try to touch on it as quickly as possible. We had a couple of people ask a very similar question. So they were wondering about these circles of support for individuals. What if a person's only support are, say, paid providers, like shared living providers or therapists or treatment team, something like that? How can you give an example of how that would work for supported decision-making?
I'll try to answer that. We understand that there may be some people in that situation, and it's a very good question. One of the things we're going to do is encourage the paid staff to try to broaden the support systems for people so that there will be non-paid staff who are involved in their lives. The advantage that we have with Nonotuck is that's a program that tends to head in that direction anyway. But that's a good question, in that although paid staff can certainly be important in people's lives, there's a potential for conflicts that has to be carefully looked at.
Okay, thank you. All right, at this point, we're going to turn this over to Rebecca Diller with the Guardianship Clinic at Cardozo Law School.
Okay, hi everyone. Just want to make sure my screen is up. So I'm going to talk more about the existing legal framework for alternatives to guardianship, including some of the ways supported decision-making might fit into that. And then I'm going to go through some strategies for promoting alternatives instead of guardianship. And I should say at the outset, I come at this from the perspective of teaching a law school clinic in which we represent individuals in any aspect or posture of adult guardianship proceedings, as well as in their related civil legal matters. And I think what might be most relevant for today's webinar, we run a pretty active intake line in which people can call really with any type of question about guardianship or any type of request for assistance. And we get a lot of calls from people who've been told by someone or some entity that they need to obtain guardianship over a family member. And they're calling really to ask us to represent them in that. And what we found is that in more often than not, in a lot of these cases, there's an alternative that can assist the person that doesn't require resorting to guardianship. So where does the need to explore alternatives to guardianship come from? Well, the mandate to explore alternatives comes up in a bunch of different ways, and I think Bob touched on this earlier. Under the Uniform Acts and under most state laws, there's an obligation to exhaust alternatives before resorting to guardianship at the outset. And I think there's an opportunity here with regard to supported decision-making to try to push courts to consider that as an alternative that has to be resorted to, that has to be considered even at the outset of a guardianship proceeding. In New York and in other states, the statutes often list a number of possible alternatives, including some of the more common ones such as advance directives, but the lists in most statutes aren't meant to be exhaustive. So I think there's room to argue for really any alternative that could be put in place for a person. And then if a person is found to be incapacitated, there's the requirement, again, that in most statutes that the powers granted under the guardianship be limited and not be plenary. And so, of course, alternatives come into play at that point in serving to limit the powers that a guardian is granted. And then once a guardianship is in place, there's an ongoing obligation to assess whether alternatives might suffice to restore rights to a person or to further limit a guardian's powers. And that was more or less the posture that the Damaris case and the Jenny Hatch case took place in, because there you had existing guardianships and the use of supported decision-making as a way to either terminate those guardianships or limit them. And then, of course, as we heard about, the CRPD, Article 12, requires the state to really develop alternatives to support the development of alternative decision-making regimes. So I'm going to talk about some strategies that I think can be used to promote alternatives. This first one really just comes from, and it's very basic, but it just comes from our practice fielding intake calls from would-be petitioners, and that is just to really focus on what the needs are in the particular case. As I said, we get so many calls where somebody says, can you help me become guardian for my mother, my brother, my father, so-and-so. And really, the first thing we try to do is just break down that request into, well, what is really going on here, and what are you trying to accomplish for this person, because there may be another alternative. Some of the challenges, of course, in this approach are that often what needs to be accomplished involves very intense legal or case management support and really expertise in a wide variety of related legal issues. So we've often seen cases where it was thought that a guardianship was needed, but perhaps there's a solvable housing or benefits or advance directives problem that could be taken care of in a different way. The other strategy that's very important is developing a comprehensive checklist of alternatives, and I think that certainly for us in our practice and for others, that this kind of checklist is always growing. So I've identified here some of the more common ones. We just talked about supported decision making. Probably the most common category is advanced directives such as powers of attorney and healthcare proxies. Then there are more informal alternatives such as friends, family, and peer support, senior centers, case management, supported housing, assisted living, assistance in the home, home health aides, home attendance, benefits rules that let family members and others apply for and recertify for benefits on a recipient's behalf. This has been something that we have found useful, that under a number of benefits programs, the Medicaid program, Social Security program, there are either regulations or guidance that let someone else assist in obtaining or recertifying for benefits. Some other options are joint accounts, representative payee programs, adult protective services, and others. Another strategy that I think is something that has a lot of potential is the development of court-based diversion programs and screening. The National College of Probate Court Judges just issued last year National Probate Court Standards, in which they endorsed this idea. They have a standard about promoting less intrusive alternatives, and in their commentary they talk about different screening devices that courts might look at, whether it's advising would-be petitioners about other options or having an actual screening unit. And I think this is something that we as advocates certainly could have a hand in developing. I don't think it exists in many places, but I do think it's something that has potential. And then the fourth strategy I wanted to talk about was creating new alternatives, specifically when a guardianship is being demanded by some third party or other entity in order to provide services to a person with a disability. And what we found, again, in our practice, I'm sure many of you have found this as well, is that often, while the whole enterprise of guardianship is justified, as an exercise of the parents' patriae power, and that it's designed to protect an individual, in many instances, really an entity or an institution is demanding guardianship in order to provide services or benefits that a person's otherwise entitled to. And so that in certain cases, the guardianship really is not a protective device. It's an added obstacle to really obtaining something that someone might be entitled to. And so another strategy to get at this is to look at, where are the third-party demands for guardianship coming from? And I think this is also probably going to be important in the development of supported decision-making, in that it's essential to make sure that entities are recognizing supported decision-making and not insisting on guardianship. So some examples we've seen are just from our practice are, a pension fund not processing a widow's benefit application because the client couldn't sign the application anymore, and demanding that the daughter become guardian in order to submit the application. A public housing program cutting off benefits, and I'm going to talk about this particular case in a moment, because the recipient couldn't sign her recertification papers, again demanding somebody in the family become her guardian. We've also seen nursing homes and hospitals demanding guardianship in order to do discharge planning and to discharge someone because of a claim that the person's not capable of consenting or managing their own discharge. So I'm going to talk about one particular case where that we handled along with one of the other clinics here at Cardozo, the Bethesda Clinic. And this was a case that grew out of really a repeated problem we had with our local housing authority insisting on people obtaining guardianships, primarily tenants who had developed dementia who couldn't sign their recertification forms anymore. And we had a particular case where a woman had received a termination notice about her Section 8 subsidy because her daughter had submitted her recertification packet on her behalf, and she wasn't able to sign a particular consent form on her own. The daughter, who was already managing her mother's affairs as her SSI rep payee, intervened and tried to work this out with the housing authority, just tried to explain, you know, I don't have a power of attorney. She didn't have a power of attorney in this case. The mother was past the point of being able to understand or sign a power of attorney, and the housing authority was insisting that the only way the mother could remain eligible for her Section 8 benefits was for her to become under a guardianship, or for the daughter to go bring a guardianship proceeding. So we brought an ADA claim against the housing authority. First, we tried to seek a reasonable accommodation. We asked that they permit us to submit an alternative form of income verification. Part of what was at issue in this case was that there was a particular consent form that the client wasn't able to sign, which would have authorized the Section 8 program to run her income through this electronic verification database. And we said, well, we'll give you something else. We'll give you something better. We'll give you proof of her income so you can see that she remains eligible for your services. They denied that, and so we proceeded with an ADA claim, which basically said that you're excluding her from participating in this program because she couldn't sign her form, and you're refusing to make a reasonable accommodation, and you're imposing this demand for a guardianship as yet another obstacle in her path. And the case, is a brief press clip, was very sympathetic because it was basically, okay, the housing authority is going to make this woman become homeless because she can't sign her form due to Alzheimer's. We ended up settling that particular case and getting relief for that particular client. They did agree ultimately to let the daughter sign recertification and other papers on her mother's behalf, and to sort of act as her, like a rep payee for her mother with regard to housing authority issues. Unfortunately, we believe that this is still a major problem for a number of tenants here, and we think it's also the type of problem that repeats in other public benefits programs that don't have provisions like Social Security and Medicaid have. But unfortunately, in this particular case, we were able to obtain relief for our individual client, and we've, in the time since then, been able to get individual requests for accommodation granted for particular individuals, but we still think there's a broader policy change needed here. And so some of the challenges of trying to create these supplemental non-guardianship mechanisms are that you still need a way of ensuring that the client acts as the central decision maker within some sort of alternative or support arrangement. And in this case that I just talked about, you know, we were confident, just based on her history of wishes, that if she wished to retain her Section 8 benefits and that she wished to stay in her apartment, that didn't seem to be in question. But I think In other instances, you know, that might be a much closer question. There's also the challenges of ensuring that clients are adequately protected, which is something that we heard about in the supported decision-making portion. And then also, I think a really big thing that we need to think about is that when a contract is at issue, you know, traditional notions of capacity to contract can become a problem for creating these alternative mechanisms. So to give you an example, in this context of the problems we've had with the Housing Authority not recognizing or accommodating individuals with disabilities, while we've made some progress on them accepting some forms and some requests from family members, you know, I think it becomes harder when you need a new contract signed, like a new lease, and I think that becomes harder also for banks and others who are the big drivers of these demands for guardianship that we see. So I think as we're thinking about supported decision-making, I do think that one of the things we'll need to think through is when these third parties are making demands for guardianship, and how do we get at that part of the problem, because at least in my practice, that's been a significant driver of the demands for guardianship that we see, or the requests for guardianship that we see. And that's it on my end.
Okay. Thank you very much, Rebecca. We have about 4 or 5 minutes before we end the webinar. We had a very quick clarification question specifically for you, Rebecca, about the ADA case that you mentioned. Someone wanted to clarify that was a complaint in federal court as opposed to a HUD fair housing complaint, correct?
Yeah, it was a complaint in federal court.
Okay. We've had a few more questions that I think, oh, go ahead.
No, but I think that's an interesting question, because in that case we didn't explore a HUD fair housing complaint as an option, but it's something to think about.
Okay. We have had several questions. I don't think there's any way we're going to get to all of them, so I want to remind everyone that these slides with the presenter's contact information will be available on the Shriver Center's website within a couple of days. We will email you all a link to that. So if we don't get to your question today, I'm sure that our panelists would be happy to address your question individually after the webinar is over. So with the time that we have left, I do want to pick up a few of these questions. First of all, what's the best forum or location where people can share experiences with making these sort of supported decision-making arguments in probate court? Is there a network where people can talk about this? And that's for any of you.
Well, if you're a protection and advocacy system or agency, then the NDRN listservs are one. There is something called the Disability Rights Bar Association, which requires a membership fee, which has a very active listserv that might be a place to do this. It may be that the Jenny Hatch project is looking at that, but I'm not sure that there is one that is directed at the United States and for probate court kinds of cases, and it might be a good idea to start one.
Okay, great. Thanks. And another one, just to, well, actually, I think we are reaching the end of our time, so we're going to wrap it up there. And I do encourage you all to contact our presenters if you have questions for them. I want to thank again our presenters and to everyone who listened in today for attending this installment of the Shriver Center's Advocacy and Action webinars. We will email you a link to this recording when it's posted. And again, if you would like to be notified when the disability-themed issue of Clearinghouse Review is published, and that will contain an article by David Hutt from today, also by Judge Glenn. They're relevant to today's topic. You can sign up for a newsletter that will let you know when that has been published. You can go to povertylaw.org/advocacy/ sign up, and check the box for news about Clearinghouse Review and other publications. Thank you all, and have a wonderful rest of the day.